certain situations, and these situations are usually rare, there are conditions where a couple will come into a divorce mediation and one of the parties has a concern that there needs to be some specific and special language in the parenting plan to safeguard the children from situations where they feel that the other parent may be not able to, or would put the kids in a situation where they might be harmed. So, for instance, if a couple were to come into mediation, if one of the parties has had a problem with drug addiction or is currently a drug addict, then the other parent may ask to have some language in there that would allow for the parent that is the drug addict to have some visitation, but there would be certain restrictions that are involved. And those kinds of parenting plans are very common, or I should say, it's very common that mediation is used for those kinds of situations. The challenge is being able to figure out a parenting plan where the party that is being restricted ultimately doesn't feel like they are in a situation where they have no hope of having that restriction lifted. So a good mediator will oftentimes help the couple to craft an agreement that gives that person some hope, that there are certain goals set. So using the drug addict example, let's pretend for a minute that mom is a drug addict and dad is concerned. And dad wants to have some restrictions in the parenting time. And yet he has belief that mom, if she recovers, is a very capable mother and that those restrictions could be lifted. A very common example would be that they would have some language that might include something where the mother is going to attend certain rehabilitation or take certain rehabilitation measures, that she will complete certain classes and that those will be endorsed by a third-party professional. That during that time, the visitation, the parenting time that she has with the children may have a third party present to ensure that there's not any problems. If mother is able to successfully complete the regimen that the father feels is fair, and it is fair, then the parenting arrangement can change and the parenting time can be modified to include a more liberal parenting time agreement where the mother is then able to have a more flexible plan. Those kinds of agreements and restrictive clauses obviously are done on a case-by-case basis. Every situation is different, and the more experienced the mediator is, the more creativity they can bring to the table in giving the couple options for that. Obviously, it requires the couple to be collaborative. If there is a perception that there needs to be a parent that needs restrictions and the other party doesn't share in that perception, obviously that can be problematic. And in those cases, you need to be mindful that if you feel that you, as that the other parent is neglectful, abusive, or harmful, and you worry that the other parent is not going to be agreeable to your opinion of that, it needs to follow the standard that the law outlines. And currently, there are laws already that define what neglect is and what abuse is. If you're a parent and you feel like your soon-to-be ex-husband is just very angry and that he yells at the children too much, while it can be argued that that is harmful to the children, it may be difficult to prove with the existing laws, that yelling at children is abusive, and therefore it's going to be hard to have any kind of language in an agreement, or that a judge would make a decision including language in an agreement for a reason like that. So it's very important that you recognize that there are situations that definitely warrant very specialized language, and the mediator can help with that. And that there are situations that you may just have to agree to disagree on different parenting styles, and a good mediator will also help coach you in being able to blend those styles and figure out where you can bend and be respectful of each other's parenting style.